Very welcome to everyone to the 9th lecture in our preparatory lecture series on the road to COP26 and CMA3. It's a great pleasure to have with us this morning Professor Lavanya Rajamani, and I'm really looking forward to your lecture today. Now, as you know, some of you in the audience have been with us for the other 8 lectures as well, and it's been a great pleasure to have you all with us to have these engaging discussions. And as you know, this is a joint endeavor between Professor Niloufar Oral, Director of the Center for International Law of the National University of Singapore, and Professor Christina Vogt, University of Oslo, but also the co-chair of the Paris Agreement Implementation and Compliance Committee. And I think this is now the latest news that I can disclose, the just new elected chair of the IUCN's World Commission on Environmental Law. So many congratulations on that, Christina. It's an honor and a pleasure to have you all with us. And I will just give a short introduction to Professor Lavanya Rajamani. She's a professor of international environmental law at the Faculty of Law, the University of Oxford, and a Germani Fellow in Public International Law at St. Peter's College in Oxford. She specializes in the field of international environmental and climate change law, and she has authored several books and leading articles in this field, including Innovation and Experimentation in the International Climate Change Regime. She's also a co-author of the Eisel Prize-winning book on international climate change law, which I'm sure many of the students in the audience will know, and everyone else is also reading. This is one of the leading books and comprehensive treatment of the UNFCCC regime and the Paris Agreement. She's also a lead editor of the 2nd edition of the Oxford Handbook of International Environmental Law, which has just been published. So this is fresh off the press. She serves as the coordinating lead author for the IPCC's 6th assessment report and has served as a consultant and a legal advisor, among others, to the UNFCCC Secretariat and the Alliance of Small Island States. She was part of the UNFCCC core drafting and advisory team for the 2015 Paris Agreement and advises governments and international organizations on matters of international climate change law and policy. So a real expert in the field in terms of research and scholarship, but also in terms of experience with the negotiations. And the title of the lecture today is Equity and Fairness in International Climate Change Law. And I think this is a very interesting topic as we are heading towards COP26 and CMA3 in November in Glasgow. And without any further ado, I will hand over to Professor Rajamani. Thank you very much.
Thank you, Petra, for that very generous introduction and extensive introduction. It's a pleasure and a privilege to be part of this very distinguished lecture series. It started with Dan Bodansky, a co-author and close colleague, and I'm looking very much forward to today's discussion after my talk. As I told Petra, I don't like to talk for long stretches of time. I'd much rather have this be interactive. So I'm going to speak for about 30 minutes on the topic, 35 minutes on the topic. And then I would very much like to have an exchange of views with those in the audience and others on the panel on this topic. So my topic for today's lecture is Equity and Fairness in International Climate Change Law. To give you a sense of how I plan to approach this topic and the structure of my talk today, I will first begin by talking about how equity and fairness is actually articulated in the 2015 Paris Agreement. I will then talk about how that articulation of equity and fairness has been operationalized in the Paris Agreement, picking up in that context how the shift how there's been a shift in both the articulation and operationalization of equity and fairness in the climate change regime from the Framework Convention on Climate Change and the Kyoto Protocol to the Paris Agreement. I will then proceed to discuss in some detail the remaining avenues for furthering equity and fairness in the 2015 Paris Agreement, picking up in particular on the limits that there are to these avenues, and then talk to the issue of fair shares, which have been picked up in national and regional climate litigation. And the reason to make that leap in a talk on international climate change law is because the issues that have proven impossible to address because of political dysfunction or political sensitivities in the climate change regime are nevertheless issues that do not die and issues that need to be addressed. And they are being picked up in regional and national climate litigation, the issue of fair shares in particular, and I will talk to that issue. And I will end with a few words on equity, fairness, and I've titled that final sort of set of slides, and beyond at COP26, because equity and fairness cannot be looked at in isolation. And in fact, perhaps the only way to look at equity and fairness is in the context of ambition and in the context of the global temperature goal that we are seeking to fulfill. So that's the structure of my presentation. I will be picking up on, especially when we talk about national fair shares, on a recent paper that I've done with a group of fabulous social science climate modelers, Nicholas Horney, Louise Jeffrey, and others from the New Climate Institute. And we've done some modeling, but a caveat here, I'm very happy to talk to the international sort of environmental law aspects of that paper. So don't ask me very detailed questions on the modeling. You know, we international environmental lawyers have our limits. So let me just start by telling you a little bit about how I think equity and fairness has been articulated in the 2015 Paris Agreement. So the preamble of the 2015 Paris Agreement picks up on quite a few elements that relate to equity and engage with equity and fairness. The principle of common but differentiated responsibilities, now with the added qualifier of in the light of different national circumstances. There are references to special needs and priorities of developing countries, to equitable access to sustainable development, the eradication of poverty, to the just transition of the workforce, and a very sort of carefully worded reference to the importance for some of the concept of climate justice. Now, the preamble, as we know, to any international instrument provides the context for the interpretation of the provisions of the agreement and sets the tenor and tone for the agreement. So the preamble, which picks up on all these elements of equity and fairness, aspects of equity and fairness, certainly sets the tone for the Paris Agreement. But the provisions of the Paris Agreement also contain various references to equity and aspects of fairness. So Article 2, for instance, which contains the purpose of the Paris Agreement and contains the long-term temperature goal, although of course not just the long-term temperature goal, it also contains a sort of qualitative goals on both finance and adaptation. Article 2.2 contains a reference to the principle of common but differentiated responsibilities and respective capabilities in the light of different national circumstances. The thrust of Article 2 suggests that the Paris Agreement will be implemented, so its predictive language will be implemented in the light of equity and the principle of common but differentiated responsibilities in the light of different national circumstances. Article 3 of the Paris Agreement, which refers to contributions, also contains a reference to the need for support to developing country parties for the implementation of this agreement. Article 4, which is the provision on mitigation, contains several references to common but differentiated responsibilities, and I'll come to some of those in a little bit more detail when I talk about the remaining avenues for equity and fairness in the climate change regime. But Article 4.1, for instance, which is the sort of genesis for climate neutrality or net zero, does contain a reference to equity and sustainable development and efforts to eradicate poverty. Article 4.3, which contains the expectation of progression and highest possible ambition, which Christina has, of course, written extensively on, also contains a reference to common but differentiated responsibilities and respective capabilities. And finally, Article 14 of the Paris Agreement, which sets up one part of what has come to be characterized as the ambition cycle, the global stocktake, is to be done in the light of equity. So there are several references in operational provisions to equity. And this is the way in which equity and fairness has been articulated or expressed in the Paris Agreement. but how has it actually been operationalized? So operationalizing of these of these words and sort of references to equity and fairness has been done through differentiation. And there are different forms of differentiation that we see in the international climate change regime. In the Paris Agreement, what we find is differentiation tailored to different issue areas. So each issue area, for instance, mitigation, has one form of differentiation, which in the case of the Paris Agreement is self-differentiation with some normative expectations attached to it, and I'll come to it in a minute. But every issue area in the Paris Agreement has different forms of differentiation associated with it. In the area of mitigation, as I said, it's self-differentiation, but twinned with sort of normative expectations with respect to highest possible ambition, for instance, or with respect to sort of progression. So let's just step back for a minute and look at the different forms of differentiation we find in the climate change regime, because this will help us understand how there's been a shift, in a sense, from one set of sort of ways of operationalizing equity and fairness to another. So differentiation, broadly speaking, can by differentiation, of course, I should clarify, I mean differentiation between either different categories of parties or different parties, and norms of international law and norms of treaty law that actually differentiate between parties in certain ways. Broadly speaking, there are two ways in which differentiation can be done. One is a prescriptive top-down form of differentiation, which is multilaterally negotiated. And that's what we see in the Kyoto Protocol, for instance, where the treaty or the instrument matches categories of parties to categories of commitments. And those categories of parties and categories of commitments are enshrined in the treaty. And that's what we see in the Kyoto Protocol and the Framework Convention on Climate Change. What we see, at least in respect to mitigation in the Paris Agreement, is a form of self-differentiation. It is not a prescriptive, multilaterally agreed form of differentiation, which is then, for want of a better word, imposed on parties. But this is a form of differentiation where parties choose for themselves what their contribution is. And by virtue of choosing for themselves what their contribution is, they differentiate themselves from every other party. So this is a different form of differentiation. So you have prescriptive differentiation and you have self-differentiation. And there's autonomy in self-differentiation. Now, there are different sort of ways in which prescriptive differentiation can manifest itself. And we find that, for instance, in the Kyoto Protocol, there's prescriptive differentiation with respect to core obligations. So there are greenhouse gas mitigation targets set to timetables for Annex B parties or developed countries, but not for others. So that's a form of differentiation in core obligations. You also have differentiation in terms of implementation between different categories of parties. Some categories of parties have longer time frames, perhaps can use different base years, as was the case with economies in transition. So there is a possibility of having a differentiation in relation to implementation of commitments, but not necessarily in relation to core obligations. And then there's perhaps the least controversial form of differentiation, where there's differentiation in terms of providing assistance, whether it's financial, technological, or in terms of capacity. What we find in the Paris Agreement is differentiation in relation to assistance, for instance. So that form, even though it is prescriptive in that the treaty is prescribing that one category of parties provides assistance to another, it's not self-differentiated in that way. So in respect of assistance, for instance, the Paris Agreement contains that form of prescriptive differentiation, continuing from the patterns that were set in both the Framework Convention and the Kyoto Protocol. But in relation to mitigation, what it contains is self-differentiation. So in terms of the kind of way in which differentiation, or the operationalization of differentiation in the Paris Agreement, we have different forms of differentiation in different issue areas. In mitigation, self-differentiation, and the capacity to sort of self-select and self-differentiate their contributions. But in relation to assistance, for instance, there's prescriptive differentiation. So what is this sort of shift that has occurred then? You have, for one, in terms of the articulation itself, of what is seen as reflective of equity and fairness, the principle of common but differentiated responsibilities and respective capabilities, is now articulated as common but differentiated responsibilities and respective capabilities in light of different national circumstances. Now, what does this addition actually suggest? It suggests perhaps that there is a level of dynamism to differentiation, that it's not static, that the differentiation that we find in the Framework Convention or the Kyoto Protocol, which is a creature of the time in which it was negotiated, is not necessarily the differentiation that we're going to see today or in 2015 that we saw with the Paris Agreement. So in light of different national circumstances, could suggest a certain level of dynamism in differentiation. We find a further shift in articulation and operationalization of the Paris of equity and fairness, in that we've moved from cross-cutting prescriptive differentiation, which is what we saw in the Kyoto Protocol, to tailored differentiation, as I explained. And this has meant that we've sidestepped annexes. We've moved towards self-differentiation, at least in mitigation. A couple of other more subtle sort of shifts that we see are that references to poverty eradication and sustainable development, for instance, that we see in the Framework Convention on Climate Change, are different from the references we see to these sort of notions in the Paris Agreement. And what is the difference? In the Framework Convention on Climate Change, they are phrased as overriding priorities: poverty eradication and sustainable development. So if you look at Article 4.7, for instance, of the Framework Convention on Climate Change, it reads, the extent to which developing country parties will effectively implement their commitments under the convention will depend on the effective implementation by developed country parties of their commitments under the convention related to financial resources and transfer of technology, and will take fully into account that economic and social development and poverty eradication are the first and overriding priorities of the developing country parties. Now, this you do not see in the Paris Agreement. There are references to sustainable development and poverty eradication, but they are references that set the context for implementation of the commitments in the Paris Agreement. So, for instance, in Article 2.1 of the Paris Agreement, which contains, as we know, the purpose of the Paris Agreement, references to sustainable development and poverty eradication are the context for implementation. A similar and related point is in relation to again the conditional relationship that is set up between support for developing countries and implementation. So the provision that I just read out, Article 4.7 of the Framework Convention, clearly creates a conditional relationship between the extent of implementation of support provisions by developed countries to the extent of implementation of mitigation commitments by developing countries. We do not find this in the Paris Agreement. So again, a more subtle but clear shift in this respect as well. So if you look at Article 3 of the Paris Agreement, for instance, which talks more generally in a cross-cutting fashion about sort of contributions, the last sentence reads, the efforts of all parties will represent a progression over time, while recognizing the need to support developing country parties for the effective implementation of the agreement. So there's a recognition that developing country parties need support for implementation, but there is no conditionality to the implementation of their commitments by developing countries. It is not conditioned on the provision of support, but it is recognized that support will enable them to sort of effectively implement the Paris Agreement. So there is a shift both in the articulation of equity and fairness and the operationalization of equity and fairness in the from the Framework Convention, Kyoto Protocol to the Paris Agreement. So what then are the remaining avenues for furthering equity and fairness in the Paris Agreement? So there are two main avenues that feed into each other as well, but there are two main avenues for equity and fairness concerns to be articulated, expressed, and addressed. So the first is an ex ante in the sense that before the NDCs are implemented, when NDCs are submitted, nationally determined contributions are submitted under Article 4.2 of the Paris Agreement, parties are encouraged to explain how these are fair and ambitious. And these derive from Article 4.8 and the rules under the Paris Rulebook and the decision accompanying the Paris Agreement. So they're encouraged to explain how these are fair and ambitious. So that's one way in which this can happen. And of course, you will immediately notice that differentiation as well here is, it's not just differentiation that has been decentralized, as it were. It is also the determination of whether it's fair or not that's being left up to states. So states are not just getting to choose their own contributions, they're also getting to explain and to provide narrative justification for why their contributions are fair. So there is self-differentiation, there's self-explanation, and as you would imagine, some of these explanations are self-serving, and I'll come to that in a minute. The other avenue for equity and fairness is the global stocktake, which is to be conducted in the light of equity, and I'll come back to this in a little bit more detail as well. So let's look at the kinds of indicators that states have put into their NDCs in relation to justifying that their contributions are fair. So as you will see, and I should say this is work that we've done. I was referring to the paper that I did with Nicholas Horney, Louise Jeffrey, and others from the New Climate Institute. We trawled through all the nationally determined contributions up to 31st December 2020. I had a fabulous former student of mine help to do this, Alyssa Glass, who's also a co-author on the paper. So we looked at all the nationally determined contributions to see what indicators had been suggested by parties as justifying their contribution as fair. And what we found is, for instance, that 111 NDCs referred to small share of global emissions as an indicator of fairness of their contribution. So countries are basically saying, well, our contribution to global emissions is so small that whatever we're doing is fair. I'll come back to in a minute to whether this is justified or not. And there's emissions per capita, right? Perhaps slightly more justified criteria. Many parties indicated that they were least developed countries and small island developing states. And so what they were doing was as fair as possible, given their limited responsibilities for creating the problem. Many referred to progression of own effort, that, and 55 NDCs refer to that, is that it's fair because we are actually progressing. You know, we're doing more than we were doing yesterday, so this is a fair contribution. Many 37 NDCs refer to historic responsibility, 27 to GDP per capita, so referencing capabilities, for instance. 26 referred to the fact that their contributions were in line with their own targets. Some, 24, refer to emissions per GDP, which is emissions intensity. 10 refer to peak year, 8 refer to least cost pathways, that their contribution is fair because this is the least cost way of doing it. Now, the obvious question for us as international environmental lawyers is, are these indicators fair and supported in international environmental law? So small share of global emissions, for instance. Why should that matter? Why is that an indicator of fairness? If you add up these 111 NDCs, 111 countries that claim that their contributions are a small share of global emissions and therefore it's fair, it actually adds up to 25% of global emissions. And every court case, or every court case that has looked at this issue, because many respondents in national climate and regional climate litigations have actually raised this issue and said, well, this is a drop in the ocean. What we're contributing is a drop in the ocean. And in many of these cases, the judges have dismissed that argument because this is a matter of common concern, and the issue is one of common concern, and everyone needs to do their part. So this is not an indicator of fairness, and none of the principles of international environmental law would justify that, right? So from well, even the common but differentiated responsibility principle, there's a common responsibility there. The fact that it's a small that their contribution is a small share of global emissions is completely irrelevant to fairness. Similarly, least cost pathways. Why should the cost that the cost of a particular measure determines its fairness. I mean, it determines its efficiency. It determines how much they should be doing of something or who should be doing it. It does not determine fairness. It does not suggest that just because it's cheap, it's fair. That's not an indicator that is relevant in terms of determining fairness. Emissions per GDP, similarly, that the emissions intensity is already quite strong, so it's hard for them to make further emissions cuts. Well, that's relevant as far as implementation of their fair share might be concerned, but it's not relevant as far as determination of their fair share is concerned. It's similarly progression of own effort. Great if you're doing more than you were doing yesterday, but that doesn't mean that you're doing enough. It just means that you're doing more than you were doing yesterday. Similarly, criteria like it's in line with our own targets. Again, fabulous, but that doesn't determine fairness. And peak year, again, great if you've identified a peak year, but just the fact that you've identified a peak year doesn't mean that it's a fair peak year for you to have taken on. So many of these indicators that states have actually put forward as justifying the fairness of their contributions are not indicators that are anchored or supported in international environmental law. So the paper that I was talking about, I think, I'll come back to the other slides in a minute, but this paper actually looks at these principles in some detail. National fair shares in reducing greenhouse gas emissions within the principal framework of international environmental law. So we look at all these principles of international environmental law and illustrate why or argue that none of these criteria are actually embedded in principles of international environmental law and so should be excluded from consideration when we're determining whether they're fair shares. So it's all very well for states to claim that these are important criteria and use these criteria to justify their contributions, but they actually don't stack up against principles of international environmental law, principles that states themselves have alluded to or explicitly referred to in their NDCs. This is also what this paper tabulates. We look at some references to various principles of international environmental law in the NDCs, and these principles don't support these criteria. Okay, the other avenue for sort of equity and fairness issues to be furthered is in the global stocktake. Now, parties are required to take stock of the implementation of this agreement to assess the collective progress towards achieving the purpose of this agreement and its long-term goals, and are required to do so in the light of equity. But if it is collective progress, how can we actually determine equity when equity is a burden sharing assessment, an assessment of sharing of burdens between states? How do we determine that if we're looking at collective progress? And so it's an aggregated assessment, not individual assessments. So how do we determine equity? So one possibility is that we could, not that this has been has had much traction in the negotiations, but you could look at what groups of parties are doing, and maybe we'll get around this notion of sort of individual assessments, which are clearly excluded from the global stocktake. But equity, notwithstanding the fact that there's a reference to to the implementation of the provisions of the Paris Agreement and assessments being done in the light of equity, I think it's challenging to operationalize this in the context where it's only collective progress. And even if we can assess it, how do we assess it? What criteria do we use? Are there indicators that can be used? Do we draw those indicators from what states have put in their NDCs? As we've seen, what states have put in their NDCs is self-serving for the most part and not necessarily anchored in principles of international environmental law, because these are self-selected indicators, right? Principles, do we look at principles of international environmental law? What benchmarks do we use? And we also need to consider what linkages there are between action and support for NDCs. So there are challenges in how we can operationalize equity in the global stocktake. And if you look at the guiding questions that the chairs of the SPI and SUBs have just released in their revised note, this was just released a few days ago in earlier in September, you will see some of these tensions playing out. And I'll come back to that at the end when I talk about COP26. But both the avenues that I've identified, which is one, providing information with your NDCs about the fairness of your NDCs, providing narrative justification, is subject to serious limits, as well as global stocktake, which is the other avenue for equity and fairness, is subject to serious limits. And it's in that context, that I alluded right in the beginning to the fact that this issue cannot be addressed comprehensively or well, so that states have a sense of ownership of the outcomes in the context of the Paris Agreement, because it was politically impossible to arrive at a multilaterally agreed burden sharing arrangement that states would agree to. So because it was impossible to do that, and the Paris Agreement did sidestep this, seemingly perpetually resolvable issue, this issue is now cropping up elsewhere, because this is not an issue that will die. Dan, who started this lecture series, and I wrote an article a couple of years ago on the Paris Rulebook, sort of highlighting the issues that will not die. So that's where I'm deriving that from. And this is one of those issues. So the equity, fairness, differentiation issues are issues that crop up all the time. They're cross-cutting issues. They will crop up at every negotiation. They will crop up at COP26 in a cross-cutting manner. They will crop up in every possible way, process and substance. But since it's an issue that will not die, and since there are only few sort of avenues for it in the international process and limited avenues for it in the international process, it is now being raised in national and regional litigation. So to take one example, for instance, a case before the European Court of Human Rights, where 6 Portuguese youth have filed a lawsuit against 33 countries, the issue of fair shares comes up, because the minute you have claimants coming before a court, national or regional court, saying that what our state is doing is not enough, the court is going to ask, how do you determine what's enough? How do you determine what's enough in the context of a global collective action problem where every state has to do their part? How do we determine what's enough? And so the question of national fair shares is coming up in litigation across the world. And it's coming up in this case as well. And the piece that I was alluding to earlier, that I showed you earlier, we were trying to determine what national fair shares should be, anchored in principles of international environmental law. And what we found is that, and so the modelers, my colleagues, my co-authors, worked out sort of, what national fair shares would be if you excluded the criteria that I was referring to earlier, that are not anchored in principles of international environmental law. Because if you included all the criteria, you have a very wide range of fair shares, which allows states to keep increasing emissions, and we will never get to the temperature goal that we've identified for ourselves in the Paris Agreement. So the first step in our analysis was to actually exclude those criteria which are not anchored in principles of international environmental law. And the next step of the analysis was to say, well, even if we exclude those criteria, we will still not get there, because there will still be quite a wide range, because principles of international environmental law have an interpretative range, as it were. So we won't get there. So if we won't get there, what do we then need to do? And then we look at the normative expectations within the climate change regime. We look at the directional pull that notions such as highest possible ambition have, notions such as progression have, and the objective of the Paris Agreement, which is in Article 2. And if we look at those, we further compress the range of fair shares. So what you see here is the fair share ranges. The bit that's below 1.8 degrees centigrade with 66% probability is Paris compatible, as it were. And if we look at these, and you can look at this in some detail with supplementary material as well. And I should say that the article that I referred to is an open access article, so you just have access to it online. It's been published in Climate Policy just 2 weeks ago. So if you look at these ranges, what you will find is that very few countries can actually increase their emissions. In fact, relative to today, it's only India that can increase its emission based on the criteria that we identified as sort of relevant criteria. I should say that is a complete coincidence, by the way. It's not because the lead author is Indian. It's just a complete coincidence there. But it's only India that can increase its emissions, and relative to today, and Indonesia relative to 2010, but not relative to today. All the other countries have Paris, all the developed states have a Paris temperature goal compatible emission level in 2030 that is net negative. Of the G20 states, only India and Indonesia can temporarily increase their emissions relative to 2010, only India relative to today, as I was saying. And the other analysis, the other sort of message arising from the analysis that is that around half the G20 states have actually increased their emissions over the 2010s, and those decreasing emissions have done so too slowly. So these were sort of the big picture sort of messages that emerged from our analysis. But please do take a look at that paper for more details. So this takes us to COP26. So to sort of recap, there are very few avenues left and in the Paris Agreement for equity and fairness to be given a full treatment. And those avenues are limited, as I've been describing. So what can COP26 do? Now, the first thing I'd like to say is that, as most sort of those involved in the process, and I'm sure Christina will agree with this, there are things that are on the agenda of the COP. And the COP can only deliver what is on the agenda, what's on its agenda. So some of the expectations of COPs, conferences of parties, are generated by the external world, generated by media and others. And they're generated in a way that the COP can never match them because these things are not within the agenda of the COP, right? But there is also a COP moment. And what has emerged actually since, particularly since the Paris Agreement, is that these COPs are much more than just about what's on the agenda. The agenda can deliver, well, hopefully we will get a rule book, we will get the full rule book, especially in markets and sort of the remaining bits of transparency. But beyond that, the moment, which is a wider landscape of ambition, that can deliver as well. So the important thing in my view, and this is not just about equity and fairness, is to connect that wider landscape of ambition and the wider diplomacy around ambition, which is occurring outside the COP process, with what's happening in the COP process, and that's the real challenge. But in the context of equity and fairness, some things are on the agenda. We are meant to be submitting new and updated NDCs by 2020. Only 118 countries representing about 50% of global emissions have done so far. And the latest synthesis report that came out from the UNFCCC Secretariat, again, it was just an updated one a week or two ago from, 17th of September, suggests that actually currently with implemented NDCs, we're 16% above 2010 levels, even if we take all the second NDCs and updated NDCs into account. And as the IPCC suggested in the 1.5 degree report, we need to be 45% below 2010 levels by 2030. We're nowhere near there. And even for 2 degrees, we need to be 25% below 2010 levels by 2030. And we're not there. So obviously, it's not just that we need new and updated NDCs from the rest of the countries. We actually need countries to go back and think about the NDCs they've already submitted because these do not add up to what's necessary. The other sort of ask that I think we should have of the COP, and the COP can do this in decision one, sort of CP26, is to find some way of aligning this wider landscape of ambition that I'm talking about, the net zero targets that countries are announcing, with what's happening in the COP process, and anchoring them in the COP process and anchoring them in the Paris Agreement architecture. So 131 countries representing about 72% of global emissions have actually either announced or adopted net zero targets, net GHG or net CO2 zero targets. But and again, a really superb analysis by Nicholas Hornig and team in Nature Climate Change just a few days ago that came out suggests that if you look at all of these NDCs, if you look at all these net zero targets by these 131 countries, it would actually put us on a 2 degree pathway, not well below 2 degrees, not 1.5, but at least on a 2 degree pathway by 2100. And if that is the case, why aren't states putting them into their long-term development strategies, and why are they not aligning their short-term NDCs, which is sort of for the 2025, 2030 timeframe, with the long-term net zero targets? And if we need to have credibility, accountability, and fairness in these net zero targets, which states are announcing and adopting, they need to be anchored in the Paris Agreement processes. Article 419, which incorporates long-term strategies. Some states have done this. Only a fraction of the total number of states have actually sort of put in long-term strategies. But of the ones that have, some of them have referred to their net zero sort of goals. But all states need to do this. And once CP 2026, the decision that comes out, can actually encourage states to do this, to put their long-term commitments on paper and align their short-term commitments with their long-term commitments, because currently that alignment is not necessarily there, which calls into question the credibility and accountability of these long-term targets. And also in terms of fairness, because when you have these long-term net zero targets, being adopted and announced, there's also pressure being brought on other countries within the context of the wider diplomacy of ambition to take on mid-century net zero targets. But mid-century net zero targets are not undifferentiated. If you look at Article 4.1, it very clearly talks about a later peaking point for developing countries, and the climate and the whole sort of thrust towards climate neutrality or net zero is framed within the context of sustainable development and equity. In fact, Article 4.1 uses the term on the basis of equity. And if it is on the basis of equity, it is not a singular mid-century net zero GHG target for every country. It cannot be. But that is what countries like India, for instance, are being pressured to take on. So what this translates into is differentiated net zero, which means that perhaps the US or others should be taking on a net zero target much earlier than they currently have, to allow room for developing countries on the basis of equity terms from Article 4.1 to do it later and to do it differently. Finally, on the global stocktake, what can we do in the COP26 moment? Now, the global stocktake, there are limits to what it can do on equity, but it can mainstream equity and fairness. And if you look at the chair's guiding questions, again, came out a few days ago on equity and fairness, they don't quite get us there, because the references that the questions that they've posed in relation to equity and fairness are, for instance, one, what information was provided by parties on fairness consideration, and how has it been reflected in their actions? Now, we know what kind of information has been provided, and if the information that's been provided and the narrative justification is that there's a small share of global emissions or it's least cost pathways, etc., that isn't actually fairness considerations at all, although they're positing that they are. And it's actually irrelevant how that's been reflected in their actions, because those are not fairness considerations that we would consider fair or international environmental law considers fair. So this question doesn't necessarily lead to a very robust conclusion on equity and fairness, right? If you're basing it on the criteria that states themselves have put forward. And the second question is, what information is available in relation to equity in mitigation, adaptation, and support to evaluate the fairness and equity of climate contributions based on national circumstances and capabilities? Now, national circumstances and capabilities are certainly relevant, but they're not the only relevant considerations for equity and fairness. So it does limit the range of considerations for equity and fairness. So the chair's guiding questions, in my view, don't quite get us there in terms of developing a robust sort of system to mainstream and operationalize equity and fairness. And the global stocktake, which the negotiations for the remaining design elements of it are going to begin at COP26, needs to take this into account. So just to quickly conclude and just sort of recap the entire talk. There has been a shift in the articulation and operationalization of equity and fairness in the international climate change regime. There are very few remaining avenues for furthering equity and fairness, global stocktake, and providing ex-ante information and narrative justification on fairness that states themselves put forward. And they have very real limits, as I've been demonstrating. The baton has been picked up by national and regional courts, and we have to watch that space to see how they determine what national fair shares are. And the COP26 moment offers us, and it's the moment, not necessarily on the agenda of the COP, offers us a chance to encourage new, updated, more ambitious NDCs, because ambition is very much aligned with equity. The two go hand in hand. That these NDCs for the 2030 timeframe have to be aligned with net zero GHG targets, and they have to be anchored in the Paris Agreement architecture to be credible, accountable, and fair. And we need to use this moment also to more robustly mainstream equity in the design of the global Stocktake. So I'm going to leave it there, but I'm very happy to take questions, and I'm looking forward to sort of engaging with the audience on this issue. Thank you.
Thank you very much, Lavanya. That was a wonderful talk and truly inspiring. I would like to encourage the audience to type your questions in the Q&A section, and I will read them out. But I would also like to use my privilege as chair and ask you a question. Yeah. That relates to the definition of equity that you have used within your group when you analyze the fair shares as they were defined by states. And so the reason I'm interested in this is I'm looking at the decision of the Neubauer case, the Federal Constitutional Court of Germany decided, and has used an understanding of international equity that the court has derived from Article 20A of the German Basic Law, but that really has turned the carbon budget almost into a freedom budget, because they're not concerned about protecting planetary rights or international equity per se. The court is really concerned with how do we distribute the carbon budget, the national carbon budget, along the timeline. So there is an intertemporal aspect, but it's not really for the sake of any environmental parameters. It's really to protect future generations in their right to make use of CO2 intensive fundamental rights. So how can we enjoy rights if they're all bound to CO2 emissions, if there have to be drastic cuts after 2030? That's really the questions they have answered. Now, in terms of the Paris Agreement, then I think there's a differentiation between international equity there as well and intragenerational equity. So the preamble only talks of the intergenerational equity once, and apart from that, it's only the term equity that is being used. So I was wondering how you bring these different elements together into an analytical framework for equity. Thank you.
Thank you, Petra. No, that's, of course, a fabulous question. And absolutely, the Neubauer case has sort of broken new ground in many respects, but certainly also in terms of its framing and the intertemporal dimension that they picked up on. So, I mean, you know, as a starting point for all these discussions is how do we define equity and how do we define fairness? And I think there are very many different definitions of equity and fairness. And as our sort of study of the indicators that states use to sort of flesh out equity and fairness demonstrates, different countries, different groupings, different philosophers have very different ideas about what equity and fairness mean. So what we've tried to do is to sidestep that question of definition, because to define is to limit, in a sense. If you define something, you're limiting it. You're limiting it within the contours of the definition. So we decided to be all-inclusive as far as our consideration of equity and fairness is concerned. And that's also been sort of in my scholarship. I haven't sort of defined and limited what equity and fairness is. But what is important to do is to look at all those different sort of, I guess, aspects of equity and fairness that are put forward and to see whether they are anchored in international environmental law, at least from my perspective and from the sort of disciplinary perspective I come to it with, is a particular notion of equity and fairness that's being articulated, anchored in the notions that we find central to international environmental law. So that's the way I've taken to sort of get around the definitional question, because the definitional question is one that's really hard to do, and you will, however you do it, you will get it wrong. You will get it wrong with respect to some sort of constituency or the other, right? So we've tried to be, I've tried to be all inclusive in that approach. Just look at all the different manifestations of equity and fairness, and the ones that you describe are very much part of it. So, certainly there's an intergenerational aspect to equity. There's an intra-generational aspect to equity. And I would even go as far as to say there's an interspecies aspect to equity. So the whole ecocentric notion, wild law that, Cormac Cullinan, who's written for the Oxford Handbook of International Environmental Law, speaks of earth jurisprudence. We're talking about equity and fairness between species, right? So there are many aspects of equity and fairness that I think are legitimate and are grounded and anchored in international environmental law. And those are the ones that we should include in our consideration of this. But yeah, the intertemporal dimension, absolutely, that the Neubauer case brought out, it's huge. Also because it isn't just about mitigation, it's sharing the mitigation burden. It's also about sharing the carbon dioxide removal burden, which will be expensive and which will be what we are left with if we do not have ambitious short-term actions.
Yeah, thank you very much for this clarification. It's very interesting to note. I'm turning to the questions now in the Q&A section. So first question is, will these excellent slides be sent to us later? So we are not going to distribute the slides, but there will be a recording in the usual place on the YouTube channel of the university, and CLL and IUCN also will make this available. So there will be recordings. And then there's one question.
Sorry, if I could just add also, so some of the statistics and all that are available online. It's an open access article that I was referring to, which has a citation there. I'm happy to put a link to it in the chat. I'm not sure whether the chat sort of extends to everybody, but I'm happy to put a link to it. It's an open access article. So those slides on distribution of fair shares and national fair shares are all sort of readily available online. Thanks.
Perfect. Thank you very much. And then we've got a question from Lena Dominelli. I wonder if you have specific guidance on how those of us planning to attend COP can influence the decision-making processes you described.
Well, it really depends on the capacity in which one sort of is participating in the COP. And as I was saying earlier, there's a COP moment. And at that COP moment, there are many side events and there are many sort of interactions that go on around the COP and even sort of panel discussions. And then there's the actual negotiations to which only the negotiators go. And those are the actual decision-making processes, at least within the context of the negotiations. And there are different channels of influence, and all of them have differing forms of influence. So I think it really depends on the capacity one is attending these COPs in. Christina, I'm sure, has something to add to that as well.
Thank you very much, Lavanya. Christina, do you want to come in here?
Well, if I may, very briefly. Well, first of all, I would like to thank Lavanya very much for your deep dive into this very important, intricate and sensitive issue of equity and differentiation. I've been enjoying your work for a long time, and every time it is, adding another piece to the very difficult puzzle. So thank you so much. I have just two very brief comments, really, if I may come in here. One is on your very helpful distinction between self-differentiation and prescriptive differentiation. And I completely agree with you on mitigation, which is based on self-differentiation. However, I think even on prescriptive differentiation between developing countries, which you kind of put into the box of support, financial capacity building and technology support, even there we see a broadening of differentiation in Article 9.2, for example, on provision of finance, or also for those who may want to come in, even though they have no obligation under the convention, and especially then on mobilization of financial support, which is a global effort where developed countries are taking the lead, but developing countries can. So even in these forts of differentiation, of prescriptive differentiation, we see a shift in the Paris Agreement. And the second point is on your very interesting paper on national fair shares and the use of environmental principles. Now, my question is really, which NDCs did you use? Did you use the first batch of NDCs that parties submitted after they, or when they ratified the Paris Agreement? Because, as you know, back then, parties did not have any guidance other than the very general parameters that were adopted in Lima and then came into decision 1 CP21 in order to identify or put flesh on the bones of fair and equitable. And now with the decision from Katowice, we have much more on it, but we haven't seen yet the next round of NDCs, and only some of the updated and new NDCs in 2020, 2021 actually use that guidance from Katowice to describe fair and equitable. So we may actually see a streamlining of how parties consider their fair shares, especially with regard to Article 4.3 and 4.4 and other elements, than what we saw in the first round of NDCs, where there was just very general and broad indicators. But I think your paper is going to be very helpful also in giving guidance to parties next time around.
Thank you, Christina. Great comment and a great question. Let me just completely agree with you on the first one. Broadly, of course, because Article 9 of the Paris Agreement is phrased as especially 9.1, sort of phrased as a continuation of their obligations on finance and the convention. There is a sort of continuation of prescriptive differentiation, perhaps the only area in which there is, but there is certainly a widening out, both in terms of donors and in terms of sort of adding that sort of self-selection element to it, is that those who are not obliged to can still select and decide to sort of contribute finance and assistance to others as well. So certainly there's definitely that. There's also sort of a change in the nature of sort of the provision, right? A lot of the provisions or sort of articles of the convention with respect to provision of assistance are phrased in passive language. So support shall be provided to developing country parties, not indicating who shall provide that support, whereas in the convention it was very clear who provides the support to whom. So there's certainly a softening or widening, the sort of politics of Paris certainly played a role, even in sort of softening and broadening the prescriptive differentiation that was carried on, but the politics did not allow it to be abandoned in the way, prescriptive differentiation to be abandoned in the way it was in relation to mitigation. So on that point, yeah, absolutely agree with you. I was just sort of fleshing that out. On the NDCs, so Harold Winkler and his team did a great paper some years ago on the criteria. So they looked at all the NDCs. This is maybe 2017, 18. They looked at all the NDCs and sort of tabulated the criteria. We built on that work and looked at all the NDCs again, just because we were also looking at principles of international environment law, which they were not looking at. They were just looking at indicators. So we looked at all of them and we sort of tidied it up, sort of updated it. But we also looked at the second NDCs that have been submitted until 31st December 2020. So that was our cutoff date. So, because it takes quite a while to tabulate everything, so we couldn't go up to March, and it's a sort of very hugely time-intensive sort of piece of work, which, as I said, this fabulous former student of mine, Alyssa Glass, did, and Frederick Hans from the New Climate Institute. Oops, I'm so sorry. So that's, 2020, December 31st, 2020. And by that point, actually, most states did have sort of criteria that they put in to justify the fairness of their contributions. So we had quite a lot of rich material to draw on, is what I'm trying to say.
Okay. Thank you very much. Now we've got a question from Pijon Shang. Thank you, Professor Rajamani, for this insightful and inspiring lecture. I have two follow-up questions. And the first is, given the tailored self-determination approach adopted in the Paris Agreement, what is the role played by the dichotomy of the developed and developing country context, division in this context? And second, could you please elaborate on how the tailored self-determination approach in the Paris Agreement will affect other environmental issues of global concern, for example, marine plastic pollution? Thank you very much. From Tsinghua University, China.
Okay, thank you. Both great questions. On the first, in terms of sort of the distinction between developed and developing countries and how that will play out in this sort of new sort of framing in the Paris Agreement. So the Paris Agreement does use the terms developed and developing countries. And the Framework Convention uses it, and the Paris Agreement uses it, and the Kyoto Protocol uses it. But these are not defined anywhere. These terms are not defined. Like equity, this is not something we define, because to define it would be to limit it, and to limit it would be challenging politically. So these are not defined. So if in the context that these are not defined, where do we look to? So although the annexes were sidestepped in the Paris Agreement, if states wanted a definition of developed countries, and certainly the like-minded developing countries would allude to this, for instance, they would go back to the annexes, because we're part of the same regime, right? I mean, it is the Framework Convention, Kyoto Protocol, and the Paris Agreement is part of the same sort of regime. They're related legal instruments. The Paris Agreement and the Framework Convention are related legal instruments. And so certainly if there are questions about definition of developed countries, we'd go back to the annexes. But that is, of course, politically sort of a hot potato. So it is not somewhere we've gone. But the dichotomy does play itself out insofar as states are self-selecting their contributions. They're doing it broadly along developing country lines, although some developing countries that have sort of considerable emissions and from whom a lot more is expected are stepping up to that challenge, even though they're broadly categorized as developing countries. So it does play itself out, but in a far more self-selected way and in sort of far more of a self-image driven way, rather than in an annex to the Kyoto Protocol or an annex to the Framework Convention definitional sort of way. And on the second question of how the self-differentiation or self-determined sort of form of taking on commitments will work in international law more generally. I mean, this is a trend that we began to see with the Paris Agreement, and to some extent, we also saw it in Minamata on Mercury, where there's a sort of suite of policies and measures, and there's some element of self-determination autonomy in terms of which of those states are going to take based on their national circumstances. And I certainly think we're going to see more of that going forward, because the Paris Agreement is a reflection of where international law and international politics and relations are at this point in time. So, the 2010s, in a sense, and the 2000s were a time of treaty stagnation. We have not seen as many treaties being negotiated at this level, with 150 heads of states there. The Paris Agreement is probably the only treaty of its kind negotiated in the last 10, 15 years. And so it is very much a sign of the times. And so we will certainly see more of these kinds of sort of approaches to international environmental law play itself out in international environmental law beyond climate change, but also international law more generally. Thank you.
Thank you very much. Now we've got a question from Caroline Foster. Dear Lavanya, thank you for an excellent presentation. Might it be possible to have the reference for the recent Nature and Climate piece as you mentioned? And then there's also, you've given that already, but there's also a substantive question. So advice for national courts about fair share problems, and also comments on equity within countries. I think you are maybe, yeah.
Okay. So advice for national courts about fair share problems. Well, first of all, it's not a problem. It's an opportunity for national courts to comment on fair shares. And national courts and regional courts are playing a very important role because this question has been sidestepped. And this role needs to be played. And it needs to be played because states are not going to take on commitments when they don't feel a sense of ownership of the outcomes. And that ownership of the outcomes, they need to feel that they're being treated fairly, right? So if there is sort of emerging consensus across national courts, and this is very hard, obviously, because it's piece by piece and, country by country, judge by judge, frankly, that these decisions are coming out. It's very hard for there to be sort of a coherent direction that they're all going in. But having said that, I have some, I generally tend to be optimistic, but in this context, I'm optimistic also because litigators are talking to each other across national lines. This is a concerted transnational movement to sort of arouse courts to answer this question of how we address climate change decisively, but the fair share question is part of that. And to the extent that courts in Germany and the European Court on Human Rights and the Dutch Supreme Court are all addressing this question, and there's cross-fertilization between these different jurisdictions and between the litigating lawyers and the sort of work that's going into it. So the work that we did on this paper, for instance, was directly in response to a demand from litigating lawyers that this is a question that we need addressed, that courts ask us for, and we don't have, international environmental lawyers coming together or climate change lawyers coming together with climate science modelers and telling us, okay, if we reduce the criteria, what are the fair shares? How do we anchor this in international law? So there's a role there to be played, of course, by academics and scientists and modelers and judges. And it's a community. It's a community that crosses national boundaries. So I think these fair share sort of responses will, coming from one court and another court, will eventually will eventually sort of bear fruit, and we'll have a much better sense of fair shares going forward.
Thank you very much, Lavanya. I particularly like the emphasis on the optimism, because I think that's something we sometimes need in this field. It can be quite dire otherwise. And as you mentioned, the case in Germany, so even so when we compare that with the theory of intergenerational equity that Edith Brown-Weiss developed in the 80s, I think we can see that they have taken at least some aspects of this theory forward in terms of emphasizing that a state has an international obligation to do everything it can not to incentivize other states to undermine the trust upon which the Paris Agreement is built. So they have really not just brought in this intertemporal aspect, but also this international obligation to pursue any efforts to build trust and to improve outcomes and ambition levels internationally. So yeah, I think every court here is required to be as creative as it possibly can within the national legal frameworks. So I've got here an anonymous question. How would countries that prioritize economic growth over climate change considerations be encouraged or forced by international law to allow international climate change targets to be met? Some argue that since developed countries have been allowed to pollute to reach the point of development they are at today, there should be more leniency for countries that are currently still developing.
So I wouldn't characterize sort of, you know, what developing country their needs are as prioritizing economic growth over sort of environmental protection or climate sort of protection. I don't think these are stark. I don't think there's a binary choice. In fact, I think that we've gone well past that sort of framing in the sense that I think most countries now realize that there is a global challenge that we need to meet. It's urgent. The latest sort of IPCC Working Group 1 report that came out a few weeks ago sort of made it very clear that the science was unequivocal. And that was the first time they used the word. I mean, the degree of certainty has increased dramatically over the years in terms of human contributions to climate change. And the potential for irreversible impacts, irreversible, widespread, pervasive impacts is now very clear. And given it's that clear, I think most states, and the summary for policymakers of these IPCC reports are heavily negotiated. I'm involved in the IPCC's Working Group 3 report. I'm sort of CLA for Chapter 14, which is on international cooperation. And one of the meetings we had earlier this week told us that there's literally, it takes an hour to negotiate 50 words, which is of course much quicker than, you know, what we would have in the climate change regime. It takes probably several days to negotiate 50 words. But so the summary for policymakers are negotiated by states, and the summary for policymakers from the last one emerged with sort of the word unequivocal. So states understand that this is a sort of daunting challenge. This is a challenge of our age. And I don't think there are any states that are just prioritizing economic growth over environmental development. I think states have constraints. Okay, states have different national circumstances. They have different priorities, and there are challenges. But the recognition that this is a daunting challenge that needs to be addressed is one that is now, I think, accepted by most states without question. So I don't think international law needs to force countries to adopt targets. I think what the step we took in Paris, you know, perhaps out of necessity, and we're making a virtue out of necessity, but the step we took was to say, well, let's make this diffuse. Let all states, states and beyond states, all actors, stakeholders participate in this process. So if you look at, for instance, the movement towards the race to zero and the work that the climate champions are doing, it's all non-state actors, sub-state actors that are committing to taking on targets. So we've gone well past the framing of this problem as something that is a dichotomy between economic growth and climate change, or something that states need to be forced into doing. States are going to need to do it because that's the direction the world is going in. Again, very optimistic take, of course, but you know.
Oh, thank you very much. So Christina, if you want to come in at any of these points and say something about the Paris Agreement Implementation Compliance Committee, please feel free. I'm moving also to the questions, but anytime, please let me know. Now we've got another question here from Sunithra Mendes. What are the missed opportunities to anchor and operationalize equity and fairness in the UK NDC? And how could the UK address that? For instance, how important would it be to address the marginalization and the funding gap on adaptation in this context?
So, the work that I've done sort of cross-cutting across different NDCs. It doesn't sort of focus on particular NDCs and what can be done in terms of sort of, missed opportunities as such. So, I mean, I can't give you a detailed answer on the UK NDC in that context, but certainly on the issue of adaptation and funding for adaptation, funding for loss and damage, and funding in general. There's a huge gap in funding. And I think one of the things that we hope and expect that the COP26 moment will deliver is an increase in finance. And we've seen this week with the Biden administration sort of pledging, more substantial finance to climate change, that things are moving in a certain direction, and we're hoping that other states will also move in that direction. There needs to be a huge step up, both in ambition, as we've spoken about, in the fairness sort of distributions of burdens and benefits that we've spoken about, but also a huge step up in finance if we need to sort of fight this battle and sort of win it. So yes, certainly I think with most developed country NDCs, the big step up needs to be on finance and support and ambition as well.
Okay, thank you very much. I've got a question now in the chat, which I'm going to read out. So again, very nice comments here about the presentation, and lots of thanks in all of the comments, by the way. I should emphasize that. And the question is, how do you see the role of the new approach of the principle of common but differentiated responsibilities as adopted in the Paris Agreement over transfer of the environmentally sound technologies? And the question is from Mahata Bude, the University of Southern Denmark.
Thank you. It's a great question. But as Christina and I were discussing earlier in the context of support provisions, there has been a broadening out and a softening, but at some level, it is still prescriptive differentiation as far as support is concerned, in the sense that support is being provided to developing countries. So the framing for that has not changed in the Paris Agreement, unlike the framing for mitigation and differentiation, which has changed quite dramatically from the Kyoto Protocol approach. So the change is softer. There is a change, but it's more subtle and softer in respect to provision of assistance, and transfer of environmentally sound technology sort of fits into that frame. But of course, having said that about the sort of shifts in the Paris Agreement sort of approach to assistance from the Framework Convention, a subtle shift, having said that, the transfer of technology is beset by problems right from the start. I mean, there are issues with respect to intellectual property rights. There are issues with respect to who owns the technology. And so much of the conversations have been around joint development of certain technologies, sharing of best practices and sort of information. So I think technology transfer is, in the way that it was conceived of with the new international economic order in the early days of international environment law, hasn't quite come to fruition in the way that was expected or hoped for. There are challenges there. But in terms of the framing itself, the framing is sort of a continuation, although a softening of it, a continuation of what has been sort of in the climate change regime so far. I see Christina is going to add to that, or maybe change.
Yes, Christina. So please come in here.
No, it's when you raise the hand, it looks immediately like I wanted to, point out something in respect to what you just said, but it was just something that came up in my mind in relation to what Petra stimulated a little bit earlier about the Paris Agreement Implementation and Compliance Committee. We had a lecture on this earlier in this lecture series, but what I can see is that there's still a need out there to understand what this committee actually is and does. There's quite a lot of focus on the compliance bit, and that's important, but the mandate is also to facilitate implementation of the provision of the Paris Agreement in an individual manner. And this is flying a little bit under the radar as a place to go to for parties to seek support and help with implementation challenges. And that can be across the board. That can be all sorts of things, whether it's adaptation planning, whether it's technology transfer, whether it's different aspects that are covered in the overall structure of the Paris Agreement. Now, the Implementation and Compliance Committee hasn't really started working yet, but it's worthwhile exploring what its potential is in terms of facilitating implementation where parties meet challenges.
Thank you very much, Christina. And we should also emphasize that in that sense, the Paris Agreement is still young because we haven't had a full cycle of reviewing submissions yet. And I think the focus probably for the next year will be on preparations for 2023, the global Stocktake, and to see what's happening there. And even that, that also hasn't happened yet. So we have to give the Paris Agreement a chance to develop its full potential, to add some more optimism here. Are there any other questions? I think I've asked all the questions in the Q&A. Someone raising the hand. I can't raise hands. I can't give permission to speak. So if you've got another question, Lena, if you put it in the chat, I will read it out. Christina, do you have otherwise any other question you would like to ask? Or yes, Christina as well. That gives Lena some time.
It's just so wonderful to have Lavanya there with all her insights. Lavanya, you were talking about the possible content of Decision 1 CP26. I have a feeling that this issue of net carbon emissions is probably more an issue of the CMA rather than the COP. So I would think it's 1 CMA 3 where this may feature, but we'll still have to see. But I just wanted to ask you, what other issues do you see could be becoming part of the, the coverage decisions from Glasgow, whether it's the COP decision or the CMA decision, because there is so much in that momentum or moment that you identify rather than in the nitty-gritty negotiation mandates. So what else would you expect to be seen to be taking up in the cover decisions from Glasgow?
Well, I would hope that they would pick up in the cover decision also the IPCC, so Working Group 1 report. So stressing the urgency and the fact that it's now, a human contribution, anthropogenic influence on climate is now unequivocal, and the urgency that generates. So I think that should be the starting point for 1 CMA 3 or 1 CP26. And then talk, because the UNFCCC synthesis report on the second NDCs has come out. So I think very much the focus should be on making sure that all the NDCs come in on time, make sure that those NDCs are, second NDCs are suitably ambitious. And I think aligning these NDCs with long-term strategy, long-term goals. I think those are the sort of aligning them and anchoring them in the Paris Agreement architecture, I think to me are important. And also, I think perhaps, the global stocktake, there's not going to be a decision on the global stocktake, at least not in Glasgow, but the processes will begin to start sort of fleshing out how it should be designed. And I think some maybe hat tips to how that process or direction in which that process should go. Going back to what Petra was saying earlier about the Paris Agreement still being relatively untested or relatively sort of young. The Paris Agreement architecture is one that relies on sort of iterative increases in ambition. So this moment, as it were, is actually a testing moment for the Paris Agreement. So if you have whole bunch of NDCs that don't add up, and there's a second round of them, and then we keep doing that, then actually what that proves is the architecture and the leap of faith that we took in the architecture in the Paris Agreement is actually not justified and is not what's going to get us to get us where we need to go in terms of the global temperature. So given that, I think 1 CP26 or 1 CMA 3 and sort of the outputs or outcomes of these conferences should be to some extent trying to determine whether that leap of faith that we took in the architecture is actually sort of justified or not. And we can only do that if we speak to the ambition of what's coming out, the fairness of what's coming out, the credibility of what's coming out, and the accountability of what is emerging from states. And like I said, stepping back a little bit, for me, the big asks going forward is connecting the wider diplomacy of ambition, which there's happening in multiple sort of fora, much beyond the UNFCCC. Connecting that to what's happening in the UNFCCC, because ultimately the UNFCCC processes are the only ones where every state has a voice. The legitimacy of that process, however glacial the progress within that context might be, however dysfunctional politics might be, that legitimacy of that process is unparalleled. So I think it's really important to actually connect these wider conversations on ambition into that process, because that's the legal architecture, and that is where every state is represented. So, I mean, I know you and I are sort of converts on the UNFCCC process, so, but maybe there are out there, there are many skeptics out there.
But it's the only game in town, and it's the way we can reach out to other states as well. I think we shouldn't forget that. So we can't just concentrate on action before our own courts. It has to be through these international negotiations. So I absolutely agree with what you've just said. And I think it's also worth pointing out that we are not going to finish the lecture series before COP26 in that sense. So there will be on the 26th another roundtable where we will discuss what has happened during COP26. I think it's really important to look beyond and not just emphasize this one event, which will be one important event, but it's a longer journey still to go. So I'm really looking forward, and I'm really grateful that you have already agreed to attend almost like a lightning talk and maybe as a hybrid event, so we can discuss the details, but it should be on the 26th of November. And we will try to, again, stretch across all time zones to make it most inclusive for everyone. Before I say my final things, I also wanted to point out, and I'm sure Linda is also in the audience, it's Linda next in our lecture series, and that brings then the pre-COP lecture part to an end. But as I said, we will have a post-COP meeting again. Now, Linda will speak on the 8th of October on the compensation question, loss and damages. So that should tie in actually the lecture that Salim Haq gave, and maybe even aspects again today from what we've heard here from Professor Rajamani. And I would like to take this opportunity to again thank you so much for your time, for your absolute insightful, fantastic lecture that you have prepared for us here. I think we were very fortunate to have you here, and our students and everyone who's listening here to have these recordings available as well. I think it's a really important material, and again something we have to do under the Paris Agreement, under Article 12, Action for Climate Empowerment. So sharing the knowledge, and thank you again as well, Christina, for doing this with us, and Nilofer Oral. I think she had serious connection problems where she is at the moment, sending her apologies, but it was a great pleasure to have you all. Thank you to the audience for all your questions and engagement, and thank you, Star Neil, who's always in the background in case something happens. And so that is my final conclusion. Christina, do you want to say, and Lavanya, final words?
Well, just express my thanks, Lavanya. It's, as I said earlier, it's always very, very insightful and very interesting listening to you, because you always come with these deep analysis, which are so important. But also thank you for your optimism. This is, I think, the most important thing that we need these days, where there is so much criticism launched at the Paris Agreement, and because we haven't really seen it kicking into motion yet, and we have to work on these processes moving forward, because they are what we have these days, as Pedro said. They are, under the UN, the only game in town. Yeah, thank you so much.
I don't think there's an option to optimism, actually. What is the alternative? You have to be optimistic.
Yes.
Thank you both for inviting me, and I've enjoyed some of the lectures in this series, and it's a pleasure and a privilege to be part of the series. So thank you very much for inviting me, and I look forward to the panel discussion at the end to dissect the COP. Thank you.
Yes. Thank you very much. Bye.